So, good afternoon, class. Based on our agreement, I am recording my discussion for this afternoon. So, I hope that you will also adhere to your part of the agreement to watch this video presentation and at the same time, fill out our attendance sheet after. Okay, so for this afternoon, we will be discussing the exempting circumstances under the revised penal code. We are already done with the justifying circumstances, so I hope that you have been able to note your questions, your concerns regarding the justifying circumstances, as we will discuss them when we meet on Friday. But today we will proceed with our discussion on the exempting circumstances and what is the effect when these circumstances are actually present during the time of the commission of the crime. So I will now be sharing my presentation to you. So as I have mentioned, we will be discussing Article 12 circumstances which exempt from criminal liability. So, what does it imply? So, of course, if a person commits a crime, but these circumstances are present, then what will be the effect? The effect will now be is that such person is exempt from criminal liability. So take note of that, okay? If exempting circumstances are present during the commission of the crime, then the person who commits a crime, who commits or makes an omission which is punishable by law, is nonetheless considered not liable for a criminal offense because the following circumstances are present. Number one, an imbecile or an insane person unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as felony, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, when he shall not be permitted to leave, which he shall not be permitted to leave without first obtaining the permission of the same court. Okay. So here, the accused is actually an imbecile or an insane person. So this is paragraph 1 of Article 12. So the person who committed the crime or the accused is either an imbecile or an insane person. So who is an imbecile? An imbecile is one who, while advanced in age, has a mental development comparable to that of children between 2 and 7 years of age. So if you can imagine, here the accused is of what? Advanced age, which means he is already beyond 18 years old. So beyond or already of the age of majority, which is beyond 18 years old. Okay? But then again, his mental capacity, his mental development is that of a child between the ages of 2 and 7 years old. So ano't karesingon? Bata-bataon pa ang iya panhuna-huna. An imbecile within the meaning of Article 12 is one who is deprived completely of reason or discernment and freedom of the will at the time of committing the crime. So if you can remember, right, delitos, no, felonies, no, culpable felonies. So the elements for culpable felonies, of course, are intent, intelligence, and freedom. So if the person is an imbecile or has the mental capacity of that of a child with the age of between 2 and 7 years old, it means two of the elements are not present. Number one, intelligence. He cannot fully understand the acts or the commission of the crime because his mental development is that of a child. Number two, Because he is deprived of reason or discernment, it only shows that he had no freedom of will to commit the crime, because otherwise, if he had normal mental capacities, then he would understand fully that such act is against the law, and number two is that he would have the freedom to choose between doing good and doing bad. But in here, because his mental age is that of a child, uh, intelligence and freedom, the requisites for culpable felonies, no, or delitos are not, the two requisites are not present. There's no there can be no intelligence because at the end of the day, the 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 mental development here of the person is that of a child. Number two, there can be no what freedom of the will of the person. Okay, next, who is an insane person and what is insanity? Insanity exists when there is a complete deprivation of intelligence in committing the act. That is, the accused is deprived of reason. He acts without the least discernment because there is a complete absence of the power to discern. So what is discernment? Later we will discuss what is discernment. And that there is a total deprivation of freedom of the will. Okay, so going back again in the elements of a crime, intent, intelligence, and freedom. So if the person is insane while committing the crime, again, intelligence is absent. Why? Because he is insane. He cannot discern. He cannot fully understand the circumstances surrounding the act. No? And there is total deprivation of freedom of will, because otherwise, if he can actually understand that such act is punished by law, then he would have the choice between pursuing the act or desisting from doing the act. No, kay kung maaram lahiya nga amo nga ito't epekto iti aging bubuhat, naiintindihan niya ang repercussions han iya ginbubuhat, then he will have the freedom of choice or freedom of will. Karuyag signon, pwede hiya pumili nga i-pursue itong criminal act or desist or diri niya ipadayon itong criminal act. But because he is deprived of intelligence, it also entails that he is deprived of his freedom to choose between evil and good. So that's why these two persons, an imbecile and an insane person, are exempt from criminal liability even if they have committed an act or an omission which is punishable under the revised penal code. So take for example, Mayada kita, we've seen so many people on Facebook, on YouTube, no, that um maupay pa kunoan mga may problema ha utok, no, that they don't get arrested if even if they were not following quarantine protocol. So may dadtuan mga taong grasa, no, they were not wearing face masks, but they were not arrested by the police. Why? Because the police also knows that under the law, an imbecile or an insane person is exempt from criminal liability because they do not understand the repercussions of their actions. They do not understand the circumstances of the act in itself. So there's no intelligence, they cannot understand, there's no freedom. Okay? Because they don't have the choice. Because the lack of intelligence on their part deprives them of their freedom of the will. Okay, I hope that is very clear on our part. So that's why an imbecile, a person who has the mental capacity of a 2-year-old or until 7-year-old, or that a person who is insane or suffering from complete deprivation of intelligence are not held liable for criminal acts because under the law, under Article 12, they are exempt from criminal liability. But who has the burden of proof? So in court, if insanity is raised as a defense, who has the burden of proof? Which means burden of proof means who has to prove that such person is actually insane? The defense now. Because this is this is exempting circumstances actually fall as a defense in litigation. So if this is raised by the accused and the defense, so, di ba, accused, and iya lawyer, amot defense counsel, and complainant, and iya lawyer, amot prosecutor. So, here, it is the burden of the defense, the person defending the accused, to establish that actually, during the time of the commission of the crime, oh, this is just for insanity. Because insane persons sometimes have lucid intervals. What is lucid interval? Lucid interval is such a time wherein a person who is insane can have normal mental processes. For example, nakatumarhiyahan ka ng psychotic na medisina, and during that time, lucid ngayon hiya, normal an iya brain function, diriya insane, but he or she still committed a crime. No, it is still upon the defense to prove that the person actually acted, no, or acted or committed the crime during insanity and not during a lucid interval. The defense must prove that the accused was insane at the time of the commission of the crime because the presumption is always in favor of sanity. So under the law, the law always presumes that all persons are sane. No? Sane nga ni, so nga ni sane, normal it pag iisip. No? Diri lurong. Diri insane. The presumption of law. The law states that unless otherwise you can provide sufficient evidence nga insane inihiya nga person during the time of the commission of the crime, the presumption always is that that person is sane or diri lorong-lorong. Sanity being the normal condition of the human mind, the prosecution may proceed upon the presumption that the accused was sane and responsible when the act was committed. Okay? The presumption is always in favor of sanity, and the burden of proof of insanity is on the defense. So it is upon the accused now or his counsel to prove that he was actually insane during that time of the offense. Diri lahiya nagpapaka lorong-lorong, no? Because pwede kasi mag-acting la, di ba? Some persons who are accused of a crime can actually just say, ala, agi, di ko naintindihan, no, lorong-lorong ako. Some people do that actually. If you've seen from the news, no, there was this woman who were actually taking some children by force, tas nadakpan hiya, tas pagkadakop na iya, she was acting insane, she was acting like she didn't understand what she did, she was acting like she couldn't she couldn't recognize any of the person, she was acting like she was mentally challenged. But no, it must be properly established by the defense, by the accused, by the person who is being litigated for a criminal offense that during the time that the offense or the crime was committed, he or she was insane. Otherwise, if there's no proof, then the law favors sanity, no? The law favors that the law will presume that such person was actually sane, not insane, sane, no, nasa tamang pag-iisip during the time that he or she committed the crime. Now let's go to paragraph 2. But take note, I have to emphasize in paragraph 2, this has already been repealed. So, or amended by the Juvenile Justice System Law or Act. Okay, so we have the special law of the Juvenile Justice System in the Philippines. So, earlier, in the revised penal code, A person who is under 9 years of age is um exempt from criminal liability. But I think you've already heard about this, no? We have already what? Increased the age of liability. So from 9 years old, now it is 15 years old. So Republic Act number 9344, otherwise known as the Juvenile Justice and Welfare Act of 2006, raised the age of absolute irresponsibility from 9 to 15 years old. So here, because this has already been raised, diri nahiya a person under 9 years of age. A person under 15 years of age. So ginpatasan na an age of criminal responsibility. So any person who commits a crime and such person was actually below the age of 15 during the commission of the crime will not be held responsible for such crime because he is exempt from criminal liability. Under Section 6 of the said law, a child 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. However, the child shall be subjected to an intervention program as provided for under Section 20 of the law. So take note, no? The child will be exempt from criminal liability, those children who are under 15 years of age, but they have to be under what an intervention program. No, so that's why we have several facilities for juvenile justice. Dito laan ay hira. Magkakami rin intervention, they will undergo trainings, no, development programs so that they can be reintegrated back to society and so that they will not no they will not commit any crime anymore, no, in the future, because here, no matter how heinous, no matter how evil, even if the child has committed murder, if he is or she is below 15 years of age, she or he is exempt from criminal liability. This is an absolute rule. There are no exemptions. No matter how evil the crime is, no matter how heinous, so long as the person who committed the crime is less than 15 years of age, then there's no criminal liability, but that child must undergo an intervention program. Most of the time, they are sent to the DSWD, so that they can be trained and they can undergo developmental programs. Okay, so that is paragraph 2. So the paragraph 2 now will say a person under 15 years of age, no longer 9 years of age. Okay, so I hope you will remember that. That is a very important concept. We have already increased the age of criminal responsibility from 9 to 15. So those who are below 15 years of age, automatically, even if they committed the crime, will not be held liable for that, but will only have to undergo an intervention program. They will not be sent to prison. Okay? Next. A person over 9, this is now paragraph 3, a person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this code. So take note, this provision has also been amended because there was an increase on the age of criminal liability. Here, instead na 9 to 15, the age is now a person over 15 years of age and under 18 unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this code. When such minor is adjudged to be criminally irresponsible, the court, in conformably with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with the surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. So this has already been repealed and amended. So take note of the material changes in the age, okay? Now, a minor under 18 but above 15. So, yan hiya, dari na 9 to 15 ha. 15 to 18 na. A minor under 18 but above 15 must have acted with discernment to incur criminal liability. So, in here. So, di ba kanina, if below 15 years old, totally what? Totally exempt. But here, those who are 15 years, above 15 years of age or 15 years and above, no, until 18 years old, or but below 18 years old, no, below 18 ha, below, take note, below, there 18. So, 15 years old and above, but below 18 years old, no, the court will now determine whether he or she acted with discernment, no, because for these persons 15 until 18 below, no, 15 but below 18, they can still be exempt from criminal liability if they did not act with discernment. But if the court finds that they have acted with discernment, of course, they can be still charged, no, or criminally adjudged or uh, considered responsible for the omission or commission of a crime. The minor is presumed to have acted without discernment, since the phrase "unless she has acted with discernment" indicates an exemption to the general rule. But here, who has to prove that the minor has acted with discernment? The prosecution must prove that the 15-year-old or and below 18-year-old has acted with discernment. What is discernment? Discernment refers to the mental capacity to understand the difference between right and wrong. And such capacity may be known and should be determined by taking into consideration all the effects and circumstances afforded by the records in each case, the very appearance, the very attitude, the very comportment and behavior is said minor, not only before and during the commission of the act, but also after and even during the trial. So the court will now determine whether actually the minor has understood what he has committed and understands the repercussions of the act that he has committed or omitted, and also his the way he carries himself, the way he answers the questions in court. But at the end of the day, the burden of proof, no, the prosecution must provide sufficient evidence to overcome the presumption that such minor did not act with discernment, because the presumption is always is that a minor does not act with discernment. So now the prosecution will evaluate the way the minor behaves, the way he responds to questions, whether he is remorseful or not for what he has done. For example, before there was a case of a minor who raped another minor, but apparently the accused here announced to his friends and he was very smug about it, meaning naghinambog pa siya nga ginrape niya ini nga minor. So apparently there was no remorse on his part in the commission of the crime. So he was still held liable for the crime of rape, even if he was just 16 years old at that time, because apparently by his own comportment, by the way he carried himself, ito naghinambog pa siya, ginduro pa niya and pagkapahiyahan babae, no, who is also a minor, no. So the court decided in favor of criminal liability. So he was still made liable for rape. But although there were also mitigating circumstances on that. So that's why he was not given the penalty of reclusion perpetua or death. But then again, he was still imprisoned because apparently during the prosecution, during the hearing, the court has determined that he has actually acted with discernment. So if the age of the accused is between 15 but below 18, the court or the prosecution must determine or must prove that he has acted with discernment. Because if there was no discernment on the part of the accused, then he is criminally exempt from liability, or he is exempt from criminal liability. Okay, now let's go to 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. So the elements: a person is performing a lawful act with due care, he causes an injury to another by mere accident without fault or intention of causing it. Okay, so for example, A had an altercation with B. Oh, no, no. A assaulted B. No. This is A, and this is B. A assaulted B. So B tried to defend himself. This one, B. But by defending himself, for example, let's just say he fired a gun to defend himself because A assaulted him. So he fired a gun to defend himself. But then, when he fired the gun, the bullet hit another bystander by accident only. It was not intentional upon B to hit the bystander. And standby la dito, no? Spectator. It was not intentional upon him to hit that bystander. But accidentally, the bullet hit the bystander, and the bystander um he suffered from an injury. So here, because B was acting performing a lawful act, he was merely defending himself from assault, so long as there was due care on his part, and he causes an injury from another to another person without fault or intention, then that could be a ground for exemption. No, kasi if he does not defend himself from the assault, then he could also die. No, so he was just performing a lawful act of protecting himself. Can you still remember? No, self-defense. But in the process of defending himself, he injures another person. For example, may nagkikitalahan era away pero naiguhan bala, then he cannot be held liable because B was also compelled to fire the gun because otherwise he might have also been killed by A. Okay, so it was just a mere accident without fault or intention on the part of B. 5. Any person who acts under the compulsion of irresistible force. So, that the compulsion is by means of physical force. No? Compulsion nga ni napiritan. Okay? That the physical force must be irresistible. So, diri niya pwede i-resist, and that the physical force must come from a third person. So, may daw sa nga tawo nga nagpwersa iya to commit the crime. For example, in the case of US versus Caballeros, it appears that Bakuli, one of the accused who was not a member of the band. So here, there was a band. Bandits ba? Bands. Gang. Which murdered some American school teachers. So may dadi the band. Band nga ni sobra upat katawo. So damo hira, no? Who murdered American school teachers. Was in a plantation gathering bananas. So inihi Bakuli, nakatuloy ang lugar where the murder happened, and the bandits came. Upon hearing the shooting, ini nga band, no, dumalagan hiya, he ran. However, Bakuli was seen by the leaders of the band. So, ang gang, sigunta na lagang para mas maintindihan. Kaya under the law, they called the band. Basta more than 4 persons band dito. Who called him and striking him with the butts of their guns. So, ginkuan hiya, balbag hiya, han pusil, no? they compelled him to bury the bodies. So ginsugo ni Ra han band Hibakuli to bury the bodies of the American school teachers. So under the revised penal code kasi any person who assists no in the what the destruction of the evidence and the body of the crime can also be held liable as an accessory to the crime. We will go to that. Who is an accessory? So here, apparently, Bakuli was charged for um as an accessory for murder. But then the court decided that he was not criminally liable for as an accessory for concealing the body of crime of the murder committed by the band because Bakuli acted under the compulsion of an irresistible force. So because if he did not follow the order of the leader of the band, then he could have been killed as well. So there was compulsion, ginpirit hiya, by means of physical force, that the physical force must be irresistible. Of course, he could not resist the force because if he resisted, he could have been murdered as well, that the physical force must come from a third person. So the physical force came from the band who murdered the American school teacher. So he cannot be held liable as an accessory to the crime, even if he concealed the body of the crime, because at the end of the day, he was just forced to do such act because of an irresistible, under the compulsion of an irresistible force. Okay? Number 6, any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. What are the elements of this one? That the threat which causes the fear is of an evil greater or at least equal to that which is required to commit, that it promises an evil of such gravity and imminence that the ordinary man would have succumbed to it. So, for example, Exaltacion and Buenaventura Tanchinko were compelled under fear of death to swear allegiance to the Katipunan whose purpose was to overthrow the government by force. So if you can still remember our discussion in rebellion, 'di ba? So if you if you swear allegiance to the NPA, you could be held liable for rebellion. No, you can be held liable. But in the case of Exaltacion and Benaventura, they cannot be held criminally liable for rebellion because they joined the rebels under the impulse of uncontrollable fear of an equal or greater injury because wala, nahadlok hira, ginhadlok hira. That's why they decided to join. So here gihapon, there is no what? There was no freedom on their part. So the crime is not what? Completed because there was no freedom on their part. They just acted that way because of uncontrollable fear. Okay? Lastly, any person who fails to perform an act required by law when prevented by some lawful insuperable cause. That an act is required by law to be done. So there's an act required by law to be done. That a person fails to perform such act, that his failure to perform such act was due to some lawful insuperable cause. So under the law, under the revised penal code, we have a crime called misprision. What is misprision? Misprision is when you fail to report to the government and the authorities any conspiracy or proposal or actual commission of rebellion, sedition, and treason. Again, balik kita no, rebellion, sedition, and treason. So if you fail to report to the government any act related to bisan conspiracy pala hiya or proposal stage pala, no, waray paginhimuan rebellion pero nagplaplano pala hira. They are proposing or conspiring to commit such act. But even so, every Filipino citizen is required to report to the authorities any plan, conspiracy, or proposal to commit sedition, rebellion, and treason. No? Otherwise, if such person, because here, di ba, there is an act required by law. So it's required upon us. Otherwise, we can be held liable for misprision of treason, misprision of rebellion, misprision of sedition. But here, for example, A confessed to a Filipino priest that he and several other persons were in conspiracy against the government, no? So may plano na liwat again to overthrow the government. Under article, a Filipino citizen who knows of such conspiracy must report the same to the governor or fiscal of the province where he resides. No, under the RPC, if the priest does not disclose and make known the same to the proper authority, he is exempt from criminal liability. Ordinary persons who do not report treason, rebellion, and sedition could be held liable for misprision. But a priest who is performing his religious profession. And din kasi nagkamay-adahin confession. No, a priest actually, he is exempt from criminal liability under the law. No, because under the law, the priest cannot be compelled to reveal any information which he came to know by reason of the confession made to him in his professional capacity. So here, if a confession is made with a priest, bisan pat hiya umamin ana nga, oo, ako ang nagpatay. So nagkumpisal hiya. He went to church, the so may dadin he perpetrator, may dadin nag-commit hin crime. So he went to church, he confessed to a priest, no. Mateya siguntaha santo ninyo, nagkumpisal hiya. Nag-amin hiya nga I killed Pedro. But then the priest cannot be compelled, no. Cannot diri pwede periton mag-testify or mag-reveal an information about such confession. Because under Rule 130 of the Rules of Court, a confession made to a priest in a professional capacity is inadmissible in court. No, bisan pa ito i-reveal hit priest, ito nga confession is still inadmissible in court because the rules of court provides that no a priest acting in professional capacity kay syempre apit yung profession pagkandakin confessions, 'di ba, with devotees. Sabi ito, he is exempt from criminal liability. So waray niya what? Here there is a requirement. What is the requirement? There is a requirement to report treason, sedition, and rebellion. But then he did not report. So pwede ba niya kasuhanin misprision? No, because at the end of the day, he is required by law not to reveal any confessions made to him in a professional capacity. Okay? So take note of that. So going back to our paragraphs, number one, if we examine this one, if this is present, then there is no what? There's no intelligence and there is no freedom upon the person committing the crime because number one, ang mental capacity niya diri kaya and he is deprived of freedom of the will. Adiluwat number two, again, the mental capacity is being considered here. There is no intelligence in the part of the person committing the crime because a person who is below of 18 years old is incapable of consent. So there is also no freedom of will. Number three, it would now depend, the freedom of will now depend on whether the person who is 15 years old and above but below 18 years old, if he committed with discernment. Because if there is discernment, then there could be freedom of will. So, makukumpleto ang freedom, intent, and intelligence. Okay? Number four, any person who while performing a lawful act, in this one naman, kay there is no intent to cause such injury. An injury kasi was only what? Caused by mere accident. So, there was no fault, there was no intention to 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 commit such crime, no? Number five, any person who acts under the compulsion, in here naman, the person does not have the freedom. Kinapiritan lang nga niya, nga buhaton, and crime because why? Because of an irresistible force that he cannot resist, no? And number six, any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. So this one naman the same, no freedom of the will because napilitan lahiya out of fear. No, out of fear of retaliation, out of fear of a greater or equal injury. Kay bangin hadto nga time inihera nga nag-swear allegiance sarang katipunan, bangin kundi ra mag-swear allegiance patayon gihapon hira. No? So those are certain considerations that are taken by the court to determine criminal liability. And lastly, number 7, and a person who fails to perform an act required by law when prevented by some lawful insuperable cause. So there is the freedom, no freedom of the will because iniliwat din etong priest is required by law not to us, not to share or reveal information with when it comes to confessions made to him. So amete though that is the concept of the exemption. So we are already done with the justifying circumstances. We are done with exempting circumstances. Soon we will moving on to mitigating circumstances, justifying circumstances, alternative circumstances, and all other circumstances affecting criminal liability. So that's it for today. I hope you learned something. So we will be meeting on Friday. Hopefully, we will have a better internet connection by that time. So I hope that you will take time to study these concepts and also to review on the concepts that I am teaching you because definitely all of these information will be included in our exam because these are very important topics when it comes to discussing criminal law and the revised penal code. So that's it for today. I hope you learned something, and I'll just see you again on Friday. Hopefully, we'll be able to meet through Zoom and we'll have better internet. You will have better internet connection by that time. But for now, I will leave you with this YouTube video. So I will be posting the quiz and the attendance sheet soon. So anyway, good evening everyone and keep safe, stay healthy. See you again soon. Bye for now.